Hi, I'm Sean Bible, and I'd like to talk to you today about adoption, specifically a step-parent adoption, which is what we see most of. Let's just start with a scenario, and that'll kind of, I think, be a good way to explain it. A woman has a child. She gets married to another man. They're married for several years. Maybe bio died, has kind of disappeared, not paid child support, not done what he's supposed to do. Stepfather decides, well, I'd like to adopt the child, or stepmother. That process can be easy or difficult depending what the other party does. I have some cases where a stepfather decides to come in, adopt his stepchild. Perhaps the biological father has been out of the picture for years, doesn't really care, you may not know where he is. Those are fairly easy. Sometimes we have people that perhaps the stepfather and mother contact the biological dad and say, we'd really like to adopt the child. The stepfather would like to adopt the child. A biological father, if he chooses, if he thinks it's in the best interest of the child, can sign what's called a voluntary surrender. Adoptions are fairly simple in those cases. Of course, if it's contested, if the stepfather wants to adopt the child and the biological father wants to stop that, then there's a possibility that he can, especially if he's been, of course, if he's been paying support and doing everything he's supposed to do, the adoption won't go through. Step-parent adoptions are really for cases where either the biological father is going to consent to the adoption or biological mother is going to consent to the adoption, or if they haven't been parenting the child, if they've been out of the picture for years, not paying child support, maybe they're in prison, they're just not fulfilling their role and have not been doing that for a long time. That's the typical scenario for a step-parent adoption. Now let's talk about the procedure. An adoption is something that you'll need to talk to an attorney about. It can get fairly complicated. Even in a fairly simple step-parent adoption. There's a lot of paperwork to do, some stuff that has to be sent to the state. There are a lot of requirements. The first step is you have to give notice to the biological father. So you're going to have to decide whether you're going to do that by publication, whether if you don't know where they are, you just have to serve in the newspaper. If you do, you have to contact them, you have to give them notice of it. You file a petition for adoption. You serve that on any interested parties. In a step-parent adoption, let's say if it's stepfather adoption, obviously that would be the biological father. Once you file the petition, your attorney will go talk to a Superior Court judge. Sometimes this can be in his office. Sometimes you have to set a formal hearing on it. You have to talk to a judge at the time of the filing of the adoption for a couple of reasons. One, the judge will have to set the court date. Unlike other cases, you do have to discuss the setting of the court date, usually with the judge. Adoption hearings are normally heard in chambers. It's actually, unlike other court cases, they're private, so only interested parties. In most court cases, the public has a right to be there. Not the case with an adoption. You have to have an interest in the adoption. You have to have some reason to be there. So they will be heard in what's called in chambers. But you have to set the court date with the judge. If the biological father or mother that you need to serve is unavailable, you will need to talk to the judge. If their address is unavailable, if you don't know where they are, you will need to talk to the judge about service by publication. We've all seen that. That's where you put a ad in the paper saying we're going to have a court date on this day. If you wish to respond, here's the attorney's name, and you need to file some kind of answer with the court. Your attorney will also need to talk to the judge about waiving a home eval. This is pretty common in step-parent adoptions. There's actually a requirement in the law that you pay for. This used to be done by the Department of Family and Children's Services. It's now done through private companies. You'll want to talk to the judge about waiving that home eval so you don't have to pay for it. It can cost hundreds of dollars. If the child's been living with you for a long time, if you've been fulfilling that role as a parent, most of the time the judge will waive that home eval, and that can save some money. After that, it's pretty much just a waiting game. You have to wait till the publication, you have to wait till the services, or if the person's been served, you have to wait until your court date. At the court date, of course, if the other party doesn't show up, if there's no objection, the judge will grant the adoption. If the other party does show up, you may have to have a hearing if somebody objects to it. For example, in a step-parent adoption, stepfather's trying to adopt. If the biological father shows up with or without an attorney, you could have a hearing. If you lose at that stage, you can appeal it. Both parties can appeal it. But it's pretty much like any other court case. You file something, the other interested parties have a right to file something in reply, and then you set a court date. Regardless of how that court date goes, it can be appealed. In between, the things you'll need to do between the filing of the adoption and having the court date. Obviously, you have to serve any interested parties. That's the most important thing. There is also a requirement that you have a criminal background check. For most people, that's not going to be a big deal. If you got a DUI 10 years ago, it probably won't stop you from adopting your stepchild. If you've been arrested on probation for child molestation, obviously that's a bigger issue, but you will have to have a criminal background search. You do have to file something with the Putative Father Registry in Atlanta. Kind of a funny thing, you pay $10, you send it to Atlanta. There is a database in Atlanta called the Putative Father Registry. That has to be done before you go to court. It's basically been set up where if a man thinks that he may have impregnated a woman but doesn't know her name, doesn't know if it happened, perhaps both parties were intoxicated at a party, that kind of situation, he can file a notice with the Department of Vital Records in Atlanta and say, I may or may not have gotten a woman pregnant. If this woman, and he gives whatever identifying information he has, pops up with a child, there's an adoption or something happens with the child, I want to be notified. So before an adoption, you actually have to send something down there and ask if anybody's filed such a thing with the Putative Father Registry. But that's pretty much the timeline of a step-parent adoptions. Most of the ones I do, usually can get done from beginning to end in 90 to 120 days. Most are not contested because if it's gotten to the point where a step-parent wants to adopt, usually the biological parent's out of the picture. They haven't been doing their job. But it is something you need to talk to an attorney about, and most attorneys will be, I'm happy to talk to people about adoptions. It's one of the few happy things that we do at our office. But certainly if you feel like a step-parent adoption is necessary, or a grandparent adoption, any kind of relative adoption, feel free to call us. We give free consultations on it, and I'd love to talk to you about it. Thanks.